Hello, this is Jason from Liberate Raleigh, and this is another Liberate Raleigh video. So the topic of the video today is continuing along with the Voluntary City book, which I have been doing videos on for previous chapters. I'm going to cover 2 chapters in today's video, and these topics are kind of sort of when people talk about and consider the idea of not having a government. One of the main things they want to know about is how is justice and the court system handled, and also the police. So today I'm going to cover the 2 chapters in the Voluntary City, chapters 6 and 7, which cover those 2 topics. The first chapter has to do with justice without the government, so court system and that sort of stuff. And what this chapter covers is the law merchant of the medieval period. It covers some other stuff after the law merchant, dealing with how it sort of transitioned into private arbitration and how that leads into the current, into the present, and how that is developed. But I'm only going to talk about the law merchant part of this chapter, because I think that's the most interesting thing, because that was a legal system that was entirely without supervision of the government. The government had no authority over it. It exercised no authority over it for centuries, and it was completely voluntary, and it worked pretty wonderfully for what it was trying to do, which was manage commercial transactions. So anyway, going back to about the 10th or 11th century, agriculture was experiencing a boom in productivity. So people were able to produce more food than they actually needed. So some people were able to go into occupations that didn't have to do with farming. So this led to things like craftsmen and also tradesmen and merchants. So they were able to take goods that were produced and transport them to other areas and sell them in different geographical areas. So as you can see, what was happening was the scope of the market was expanding, such that it wasn't simply localized to a single city. Merchants were carrying trade to other cities and other countries. So one of the problems that they ran into was that there was no common code of law for merchant transactions that happened to occur from one city to another. So the merchants needed a way to get around this. They needed a solution for the problem of localized customs. They needed a common legal system that would be able to manage any sort of disputes that might occur between merchants in different cities and different locations. So they came up with this law merchant, and it was very successful, and it covered pretty much all of the merchant transactions pretty much across Europe and even outside of Europe somewhat. After the 11th century, about the 11th century AD, after that, it pretty much handled all of those transactions between cities. So this was how they got around it. And the important thing is that it was completely voluntarily agreed to, and there was no government authority that was putting the proverbial gun to people's head and submitting to it. So this is when it started, around 10th to 11th century, and by the 11th century, it was pretty much managing, for all practical purposes, all merchant transactions that were occurring in Europe, and also in some areas outside of Europe. So how did the law merchant form? how did they go about doing this, and how are these things handled? So what they ended up doing was merchants would form courts in different cities, markets, and trade fairs that would handle disputes that might arise between two different merchants. And this was done via a participatory process wherein the courts, the judges in these courts were composed of the merchants that were trading in that area. So they tended to be chosen based upon their knowledge of the given sorts of transactions that might occur. So they would try to find people that were experts in that area of business practice. So they would form these courts, and then the other question is, so how did the various laws and customs that were enforced come about? So what they would do is they would the customs and laws that arose were the ones that were most common amongst a great number of different cities and markets. So it wasn't let's say there was an idiosyncratic custom in a particular city, and this custom existed only in that city. Well, that wasn't the sort of custom or law that would end up being enforced by the law merchant. What they were looking for was they wanted to facilitate trade amongst the greatest number of cities. So it was those laws and those customs which were common to pretty much every city that the merchants would be trading in, which were the ones that ended up being enforced. So if there was a particular rule or custom, say something like you don't get to steal money from somebody's account or something, that pretty much no matter where you went in Europe, that would be upheld. That was the sort of custom that the law merchant would implement. And the reason why those particular laws, those particular rules would win out for enforcement over the rarer idiosyncratic laws was because the benefits of widespread trade was greater than, say, maybe some specific benefit to a small group of people that could benefit from an idiosyncratic localized rule like that. So if it benefited if it was just something that only happened in a particular city, then maybe other merchants outside of that city might be less willing to participate in exchange in that particular market, but that would hurt everybody involved. So the benefits of rejecting those rare customs and rules that were highly localized in favor of those that were geographically well accepted over over the largest areas would win out. Those were the ones that would win out because there were benefits to being able to trade with a common quote-unquote language communicated through the customs over over the largest possible geographical area. So as I just said, it was only those customs that were widely agreed upon by many merchants across a large geographical area that were ultimately accepted. So now the question might be, so what does that refer to? What sort of laws, what sort of rules are we talking about? And those particular rules that were most widely accepted by the most number of people, pretty much all over Europe, were those customs which enforced business practice, as in those customs which would enforce the idea that merchants should live up to whatever obligations they voluntarily agreed to. So if two merchants came to an agreement and one merchant would provide a certain good, a certain quantity of a good, and then the other merchant might offer a payment, the custom that would come into play, that would arise based on that, is that each side would have to live up to those obligations. And so they also had the concept that the obligations and the agreements were entered into fairly, so that people don't like to be bound by rules that they don't think treat them fairly. So the stipulations for what constitutes a particular agreement were those ideas of fairness for entering an agreement which were most widely accepted by the most number of merchants involved across Europe. So this would lead to, because these agreements were entered into fairly and the customs were only upholding that which the merchants involved agreed to, so that they were only the only enforcement was to get them to live up to their obligations that they agreed to in a fair context. These obligations were the decisions of the courts were accepted by both winners and losers, because again, they were widely accepted as being fair rules. The agreements were considered entered into fairly, and so whether somebody won or lost their dispute, they were voluntarily accepted. So then the question is, well, why does anybody have to accept these sorts of agreements? Why doesn't somebody, they bring something, they bring up a dispute to the court, the law merchant court. The law merchant court says, no, I'm ruling in favor of this other person, so why would anybody agree to it? Why wouldn't they just say, no, to heck with that. I'm not going to live up to my obligations. I'm not going to pay the restitution fee or whatever. Well, the voluntary enforcement mechanism was pretty much, everybody knew that if you became a bad actor and didn't live up to, didn't voluntarily agree to the decisions or live up to the obligations that any decision against you would entail, that you would suffer severe damage to your reputation. And this would, in some instances, could potentially greatly damage your business, because then people, other merchants, once they know that you don't live up to the decisions of the law merchant courts, they are much less likely to do business with you. So this ostracism, social ostracism, which is a very powerful enforcement mechanism and is entirely voluntary, is extremely powerful to get people to cooperate with each other and agree to rules. And again, this mostly comes as another big factor here is, again, the idea that these agreements were considered to be entered into fairly by those parties. So here we have this legal system was voluntarily created and designed, and also the enforcement mechanism was purely voluntary. So also at this point in time, there were royal courts, which were pretty much government courts, that also existed. So the question might be, well, why did merchants choose the merchant courts over the royal courts? Well, in addition to those things which the fairness of the customs and that sort of thing, the other thing is that the merchant courts would have people that were knowledgeable in those areas that the disputes were being brought up in. And the other important thing was the process was much more streamlined relative to royal courts, and it was a much speedier process. As you can imagine, this was very important for merchants who would want their disputes settled quickly so that they could continue to get on with the business of doing business. It's hard to trade when you're tied up in a court trying to figure out what the outcome of a previous transaction might be. So the royal courts were at a disadvantage because they didn't have the judges involved didn't have the specific knowledge of the merchant courts, and they were not as they were not as speedy or fast in resolution. So one of the ways that the merchant courts were speedier and faster is that, well, the process in general was designed to be quicker, so that the merchants could get on with their business. And one of the ways that they did this was they did not allow appeals. So once you went to the merchant courts, the decision was final, and that was it. You couldn't simply appeal it and draw out the process. Now, this was of benefit to merchants, as I said, because they preferred quick resolutions to something that might be long and drawn out. So in this case, this was another mark in their favor. So merchants would almost exclusively choose the merchant courts over the royal courts. They were simply, and when you think about it, they were designed by merchants for merchants, and they were subject to theoretical competitive pressure. If the merchant courts were awful, then there would be nothing to stop a competing merchant court system from arising. So the merchant courts had to actually cater to the their quote-unquote customers in order to so that they had to keep producing customs that were widely accepted, and also have a process in place that catered to the needs of the merchants. So over time, the royal courts sought to overtake the merchant courts and shift their caseload from the merchant courts to the royal courts. And the reason for this was that the judges were paid out of litigation fees from their caseload, so they had an economic incentive to get more cases. So they wanted to go about shifting the caseload from the merchant courts to the royal courts. So they had competition from the merchant courts for centuries. So the only way that they could win over business from the merchants was to apply the merchant code of law equitably and fairly in the royal courts. So for a while, it was pretty much the royal courts were simply applying the law merchant in the royal court system, but that they weren't really able to make too much headway, and the merchant courts were still greatly favored. The real problem, and this was what ultimately led to the degradation, the ultimate shift from the merchant courts to the royal courts, were statutory passing of statutory laws. And there were two in particular. One was of minor import, but the other one was pretty much devastating. So the first one said that any decision in a merchant court could be appealed in a royal court. So if a merchant court said, no, I rule in favor of the other person, then they could go to a royal court for an appeal. But this didn't have, this had a little bit of an effect, but it wasn't that damaging, because they weren't appealing the customs themselves, like the rules and the laws that were being enforced. It was still the law merchant customs that were being enforced. They were simply appealing the decision. So that didn't really lead to too much of a shift. But the ultimate problem was when, I believe it was in 1609, there was a decision that said not just the decision, but the actual law and custom that was being enforced itself could be appealed. And that was the real problem, because what would happen is that shifted the voluntarily granted authority of the merchant courts over to the royal courts. So it wasn't something that was voluntarily agreed to by anybody. It was simply the government stepping in, and they had this this decision and ultimately the final authority no longer rested within the voluntary apparatus of customs and enforcement of the law merchant. These things were forcibly taken and moved over to the royal courts, and that was the real problem, because now, since the authority no longer rested with the merchant courts, there was really no point in, ultimately people shifted over to the royal courts because they had forcibly taken the authority away from the merchant courts. And it wasn't that the merchant courts weren't working well, it was actually precisely because they were working very well, and this was the only way that the royal courts could win the competition. Now, as I said, this didn't completely kill the law merchant, and it in some sense exists even up until this very day in the form of private arbitration. So this didn't actually completely disappear, but I'm not going to get too much into the private arbitration aspect of it. You can, again, I highly recommend the book The Voluntary City. You should pick it up and read more about that history. I just wanted to cover this historical example where a legal system was entirely voluntarily implemented and enforced, existed for centuries, was highly successful. So I just wanted to cover that particular thing so that anybody watching this would know that definitively there was a voluntarily agreed to non-government legal system that existed and was very successful for a very long period of time. So this brings me to the next chapter, which has to do with policing and crime control. And this chapter covered the period from, say, about the mid-18th to mid-19th century, and it talked a lot about what was going on in Britain. So at this period of time, the responsibility for bringing a prosecution for a crime rested with the aggrieved party. It wasn't that the government would go about seeking perpetrators and prosecuting them. If something happened to you, you were the one that was responsible for bringing that up. You had to bring that to a court. So what this meant was all of this had to be handled through private means. The government didn't handle it for you. So in for example, many parishes at the time would have a part-time unpaid constable who would help to facilitate the prosecution of crimes that may have occurred against the parishioners. So he might do some investigation, might try to find some information relating to the crime, gather some evidence, and bring that prosecution up in the courts. But what actually ended up happening a lot was, and in fact most of the crimes didn't even make it to the courts for being prosecuted because they were handled through private agreements between the victim and the criminal. So a lot of this was just simply handled outside of the courts, and the system, like for example a constable for a parish, for example, would investigate these things, and then the aggrieved parties might come together and come to some sort of agreement to make the victim whole. And then this, again, most of the crimes were handled outside of the court system. Now, over this period of time, there was a lot of economic progress and industrial progress and advancements in transportation going on in Britain. So what this meant with relation to crimes and criminals was it became easier to disperse, say, stolen goods over a much larger period, greater geographical area, so something could be stolen in one city and sold in another. This created a problem because it became more difficult to go about tracking down criminals. However, the civil society, the private provision of various services, which is what civil society is, generated a response in the form of advertising. So what would happen is if somebody was a victim of a crime, they would go and advertise that they were looking for information relating to that crime so as to track down the perpetrator, and in most, if not all cases, a reward for information that would lead to either a prosecution or the return of stolen goods or compensation would be rewarded. So people would advertise, and the advent of newspapers were a very big tool that was used at the time. So people would advertise in the newspapers, and this would lead to what was referred to as impersonal detection, a system of impersonal detection, which was defined as the investigation of crimes by disinterested third parties. So let's say somebody steals something from me, and I start advertising to find out, I want to find out information about where this stuff may have ended up or who it was that took it. Third parties might step in because they see the reward and say, okay, well, I have some information, and they will step up and provide it. But this also would mean that other people, these third parties, once they see these rewards and advertisements, in these advertisements, might actually investigate these crimes on their own so as to find information. So this initial step led to a wider net being cast as far as the ability to investigate these crimes. So as you might imagine, going through the trouble and cost of doing these advertisements might be somewhat prohibitive for an individual. So this led to the rise of a particular voluntary institution which served to handle this sort of thing. And these were called the prosecution associations. So what this was a group of people that would come together, and they would say, okay, we're going to form this association, so if a crime happens to any of us, we can pool resources in order to handle the cost and effort of going through the investigation, advertising, and trying to find information in order to rectify the situation. And how it was implemented was that they would people would come together and they would have, say, a subscription fee involved, and this would defray the costs of doing all this legwork and advertising relating to the prosecution, and then the association would handle all of that. And it made a lot of sense because you don't want to, this isn't the sort of thing that you really want to typically handle by yourself. If you can if you can get a group of people together, then you can spread the costs over every one of you, and it makes sense because even if you don't use it, you have that assurance that you have that backstop. And typically what these associations would, the size of the associations would be relatively small. They typically ranged from 20 to 60 people initially, and their membership would fluctuate a little bit, but that was probably the average range of them. But however, there were many of them. There were some estimates in the Voluntary City chapter relating to this that said that there were likely thousands of them. So while they may have been relatively small, there were thousands of them. So this was a very effective and widespread means of handling the situation of crime investigation and prosecution. So as I just previously said, the prosecution associations would handle the costs and legwork of investigating these things, these crimes, and this would be done via a subscription fee. Some prosecution associations would also act as insurance for their members. So if somebody was a victim of a crime, even in the instance where perhaps they couldn't find the criminal or couldn't prosecute the criminal or come to some sort of agreement wherein the victim was compensated, they might still give some sort of reimbursement payment to compensate their people, to compensate their members. So that was another area of service that over time the prosecution associations would provide to their members. And the other thing was, and this is where they take another step towards private policing, they would organize watches and patrols of various geographical areas, like various neighborhoods and streets. So this was a good deterrent in the sense of criminals are less likely to prey upon areas where there is actual watch or patrol involved or present. But you might one thing that you might be thinking is, well, what about the public goods aspect of this? So if there's a watch or a patrol that patrols a given neighborhood, then whether or not you pay the subscription fee for the association, then you still sort of benefit from it. Well, the way that this worked was the prosecution, the prosecution investigation services that the prosecution associations would provide were tied to the watches and the patrols. So you paid into it for the prosecution services that they would provide, like the investigation and the prosecution defraying of those costs. And as an additional benefit, that they would provide the watches and patrols. So since those two things were tied together, that helped to eliminate the public goods problem, because I mean, if you want your crimes that may happen to you to actually be investigated and prosecuted, and you actually might want to get some sort of compensation for restitution compensation for it, then you have to be a member of one of these associations. And so as an additional benefit, they were able to use some of the funds towards watches and patrols, which was another step towards an actual private police force. So what sorts of crimes were these prosecution associations mostly concerned with? Well, they were concerned with responsiveness and prosecution as a deterrence. And the sorts of crimes that they would look into would be crimes against person and property. They would not concern themselves with, say, crimes against morality, like, say, drunkenness or something like that. They would almost exclusively deal with only crimes against a person or their property. Now, at the time, there were other voluntary associations that might try to combat these crimes against morality, but that's a whole separate category of institution. As far as the prosecution associations were concerned, their focus was crimes against person and property. And this was important because at the time there were reformers that wanted to reform the policing system. And they, in addition to crimes against person and property, would consider an alternate way of dealing with crime and providing deterrence. And this was via the method of regulation and control of the lower classes, where I guess most of the crime was occurring. So the policing reformers thought that if they had more regulation and control of what the lower classes were doing, then this would be a good way of preventing crime. However, the prosecution associations did not do that. They were simply concerned with getting restitution for their members through investigation and prosecution, and also by engaging in preventative measures, as I said earlier, through the implementation of watches and patrols. So in the early 19th century, the prosecution associations continued to grow fairly rapidly, and they also became more interconnected with each other. So this led to much greater cooperation between different prosecution associations. They were able to continue to provide more services to their members, and they pretty much were virtually a private police force, and they were again focused on crimes against person and property. So in contrast, the elite reformers that wanted to reform the policing system were concerned with public order and moral degeneracy, and particularly the latter was a big concern of theirs. So they wanted to use criminal law to suit those, to enforce those beliefs. And this led to the idea that the police force should be used as a mechanism to regulate the lower classes of people, which were termed as "quote unquote" dangerous classes of people, where most of the crime was occurring. And two such groups of people that were singled out frequently were Jews and Gypsies. So we have on the one hand these prosecution associations, which were voluntarily built up and implemented, that were focused on preventing crime and investigating crime and getting restitution for crimes for their members. On the other hand, there were the policing reformers. Many of them were disciples of Jeremy Bentham, the Benthamites. They wanted to use the police force as a way to alter morality and also to regulate the behavior of lower classes and just in general classes that were deemed dangerous. It was those latter arguments that won out, so they implemented this through the government and local public police forces started to pop up all over the place. And eventually what this did was it ended up crowding out the privately implemented prosecution associations. So here, like in the case of the law merchant, we have a very successful system that was in place. It didn't disappear through any failure of its own. It was simply the machinations of the government stepping in to take over the responsibility and crowding it out. So again, these are two instances where a legal system and policing services were provided entirely voluntarily, without the authority, the coerced authority of the government stepping in and forcing people to participate in a system that they may not like or want to agree to. And historically, it looks like they were very successful and did a great job doing what they were supposed to be doing, which is managing disputes, resolving disputes, or investigating and prosecuting crimes with the goal of getting restitution for the victim. So that's the end of this particular video. I hope these historical examples from the book Voluntary City, chapters 6 and 7, were interesting. And again, I highly recommend that you get the book and read the chapters. I'll probably say this in every video. I don't cover nearly all of the details involved. I'm just trying to give a general high-level outline of what's going on so that you might want to look into it more yourself and learn more. And again, the Voluntary City book that I'm currently reading is an excellent starting point. So again, that's the end of this video. I hope you enjoyed it, and I will see you in the next video. Have a great day. See you soon.